Thank you. Whenever you're ready, turn your mic.
Thank you. Mr. Jones, before the break, we were talking about this lawsuit that you brought, right? You remember
Yes.
that? Okay. And again, this lawsuit was brought against Mrs. Wu, Mr. Kimmel, and the Young Turks LLC for them stating online that you had sent child pornography to the plaintiffs in this case, correct?
They said more than that.
Okay. But was that the gist of it?
No.
Tell me what you sued them for.
I mean, they said that I intentionally did it and that I was, horrible. They said a bunch of stuff. It was a lot of different program shows.
Okay.
And we,
Okay. But the gist of the lie here was that you had sent child pornography to the plaintiffs in this case, yes?
Yes, not that it had been sent to me unopened, then discovered by you and discovery sent to you.
They left that part out, correct?
I don't remember now.
Okay. But that would have been important context for them to provide an accurate account of what happened here, correct?
Yes.
Okay. And they didn't do that.
Yes.
Right. And as a result of those statements, you claimed that this had resulted in viral spread of this lie about you, correct?
Yes.
The Young Turks had a Twitter account. They posted it to that, correct?
They have a popular television show that's also on television, and the issue was I
just asked you about the Twitter account, sir. So let's just go one step at a time. I mean,
Okay.
the concern you had was that this lie about you was spreading online, correct?
Yes.
In a viral way, right?
Yes.
And what you meant by that was that it was taking off online, correct?
Yes.
And reaching a wide audience, yes?
Yes.
And the more people who come into contact with this, as you called it, one of the worst smears that can be spread about anyone, the more people that came in contact with that, the more damage was being done to you, correct?
I mean, I think that's fair to say.
And because the more people who see this, the more people who might believe it, right?
Well, I don't know they're going to believe it, but
That's the concern, right?
yes.
Because if people believe, especially a large number of people who encounter this lie on the internet, that you possess child pornography, that would be a horrible, horrible stain on your reputation as an individual, correct?
I think it's 20 years in prison, too.
Correct. They accused you of a felony, didn't they?
Yes.
And not only just any felony. I mean, assault is a felony. But this is a particular kind of felony, possessing child pornography, right?
And distributing it.
And distributing it. And it's the type of allegation that would provoke a lot of anger in people who if they were to believe that about you, right?
Yes.
And might provoke people to even want to confront you about it, right?
Objection calls for speculation what might occur.
Sustained.
I think you testified earlier that you have come across people who have accused you of this, right?
It's still ongoing.
Right. And if that happens, obviously there are certain measures you need to take to try and protect yourself from people who may need to do you harm as a result of this, right?
And when they stop saying it, we drop the suit. We just want them to stop saying it.
But I'm just saying, when people believe something horrible like this, that you're a child pornographer, that could lead to people who believe it to hate you, right?
Objection calls for speculation.
Overruled.
I mean, I think that's fair to say.
And if they really believed it and they really hated you, you might have a few people come after you, right?
Objection speculative.
Overruled.
Well, like the police.
That's one, right? But what about people who are just out there and unhinged, thinking, Alex Jones, child pornographer, next time I see him, boy? That's a concern, right? It's a reasonable concern.
And they name my name. I didn't name most of these people's names.
Yeah, I'm not asking you about that, right? I know you might kind of see where I'm going here.
Objection.
I do.
Move to strike.
Let's move on to the next question.
And as a result of that concern, you yourself have taken measures to protect you and your family, correct?
We have to have more security because of the Sandy Hook thing, actually, than that.
But you got security guards in the courtroom right now, don't you?
Yeah.
These two gentlemen over here in the black jackets, that's part of your security team.
Yes.
They follow you everywhere you go, right?
Yes, not due to the fake child porn, but due to this.
You've had a security team for a long time, haven't you?
But the main, I mean, you're asking.
I'm just asking you, have
Objection,
you had a
motion
security team for a long
limiting
time?
doors,
It's a yes or no, whether he's had a security team for.
why? Objection.
4 years since the Sandy Hook suits.
And this gentleman here on the right, that's Tim Enwell, is that right?
Yes,
Okay, he's your head of security?
yes.
And they walk around with earpieces, right? So they can communicate with one another?
I don't know they have those.
You flew up here on a private jet, is that right?
A charter plane.
Charter plane, okay. And so one of the reasons you do that is because you travel commercial, you know who you're gonna run into, right?
Since this case, yes.
Okay.
Since the Texas case,
Mr.
it's
Jones, do you really wanna?
bad.
It's not a big point here, but you are under oath, and so I just wanna ask you.
Objection, Judge, again.
So let's just get the
Is it
next
your testimony?
question.
Objection,
That
we have
you've never
Right,
chartered?
just 1 second. Sidebar, please. So, I'm gonna get this. I don't want to be interrupted. So what do you suggest? You're talking. I can't hear what you're saying. Can we stop? Can we stop it?
I objected to his instructing counsel, which is the role of the court. You've been said that
Right, so if you haven't, you just, I don't want to interject myself more than I need to, but if you're not, just ask me. And I'm happy to do it.
Yep.
So just as a gentle reminder, Mr. Jones,
Yes, ma'am.
just try to listen to the questions I asked. If there's an objection, we'll stop, and then, and then, yes or no, or I don't know, right, I'll look, okay?
Is it your sworn testimony that you've never chartered a private jet before this lawsuit, sir?
Yes,
Never, before 2018, had you chartered a private jet? You sure you want to say that?
yes,
All right. So in the financials that you turned over to us, we won't see any expenses prior to 2018 for any private chartered air travel, correct?
you said a jet. I mean, I think we rented Cessnas for aerial news shows at the border. One time, me and my wife and my children were in Canada. We rented a seaplane that flew us for a couple hours up to a place to eat. But other than that, I've never known. Not till now. Not till this.
Okay, so your testimony is that prior to this lawsuit, you actually did fly on chartered planes, correct?
No, you said a jet.
I'm sorry. If I was confusing you, but with the word jet.
Would a hot air balloon count? I have also rented those a few times in my life.
Okay, let's,
No, that's not what I was referring to. But
I have rented.
all right, so,
I,
let's
go ahead.
just wait for questions, there's no question.
Just see if you can answer this yes or no, sir. Prior to this lawsuit, you had paid for chartered private air travel, correct?
Yes, not jets.
And in addition to the security team that you have and your private air travel arrangements, I take it that you have security systems at your homes, correct?
Sure.
And obviously at your office, you have pretty extensive security at the InfoWars offices.
Yes.
So with this lawsuit, why don't we bring up paragraph 7 on page 3.
Has it been admitted, Judge?
I think I did offer it.
I don't know the doors are open.
I think you moved it to the sideline.
Which number was it?
424.
424.
424?
It
34.
was objected to?
434.
Yes, 434 was made a full exhibit about 45 minutes ago.
So let's pull up paragraph 7 with my critique, please. Okay. And this is a complaint that one of your lawyers, Robert Barnes, drafted on your behalf, correct?
Yes.
It was filed in a lawsuit to commence this lawsuit against these people.
Yes.
And one of the claims you made was that on June 17th, 2019, at 9:44 p.m., the Young Turks by and through Cenk Uygur. That's somebody associated with that group, yes? Cenk Uygur is a person associated with the Young
Yes.
Turks. Published on its Twitter account, quote, Alex Jones sent child porn to Sandy Hook parents. See Exhibit 1. The Young Turks Twitter account. And that's the same headline made the Young Turks video page, where it still stands today. And so there was a tweet, right? And there was a headline associated on their video page, according to this paragraph, correct?
I believe so.
All right. And if you go further down, you say here that they hold themselves out as, quote, serious journalists with millions of followers across multiple social media platforms and the biggest media network on YouTube that is completely monetized by YouTube, et cetera, correct?
Yes.
And the point of that is to show that these people who you claim lied about you had a significant platform that could result in significant harm to you, yes?
Yes, and we weren't allowed to respond back because we weren't on that platform.
Okay. So, I'm just right there.
Sustained.
So, you then go down further, and let's go to paragraph 12. One of the things that you were bringing this case for was something called defamation per se, right? In a claim for defamation per se, the words are so obviously hurtful that they require no proof that they caused injury in order for them to be actionable. Accusing a professional of deliberately sending child pornography to opposing attorneys, a serious felony, raises no questions as to its negative effect on your professional reputation, right?
Yes, they said my name.
Yeah, right. The idea is that this type of allegation is so hurtful that just the fact that it was made shows that there was damage done, right?
I'm not a lawyer, but under the law, if you say their name, you have to say the person's name.
Yeah. You're not a lawyer, are you?
But
Right. So you're not, right?
No.
Okay. And when you did this, you attached as proof. Oh, let's go to page 6. Yeah, page 6. And at the end of it, after you made these allegations, you said, wherefore, plaintiff respectfully prays for judgment against the defendants in a sum to be determined by a jury, right? Did I read that correctly?
Yes.
And as proof of the harm that you suffered as a result of this, you included an exhibit. And let's go to Exhibit 8. I'm sorry, page 8. This is Exhibit 1. Oh, thank you. Appreciate it.
I'm sorry to interrupt, counsel, but you're referring to an exhibit that's part of this exhibit.
Yes, thank you. There was an Exhibit 1 attached to the complaint. Thank you.
Can we come around to see the board here?
Yeah. Thank you.
Sure.
Excuse me.
Yeah, I'm not going to use it just yet.
Let him just get situated so he can take this.
And as you see, here, this is the tweet that was so concerning to you, right? And there's a video associated with it, obviously not here on the printout.
No, it was what they said in the video where they said I was going to jail and I did it on purpose and a bunch of other incredible stuff.
I'm going to strike that, Your Honor.
Okay.
Sustained.
What you included in support of your lawsuit was this, yes?
Yes, an image of the video so you can see the video.
And the headline was Alex Jones sent child porn to Sandy Hook parents, correct?
Yes.
Now, as a technical matter, your agents did send child pornography to the Sandy Hook families. As a technical matter, correct?
Yes.
Okay. And down here, if you look at the bottom, how many retweets did this tweet have? You might have it in front of you, sir, if that's easier.
20.
20. And how many likes?
37.
Okay. And then over here, this is 132. Those are comments, yes?
I don't know.
You don't remember that? Okay.
The issue is the video, not a link.
I didn't ask you any questions, sir. All All right, you can take that down. So there were 20 retweets and 37 likes, right?
Yes.
Okay, so we're going to put TYT, that's Young Turks, right?
Yes.
So there were 20 retweets.
Do you need Mr. Jones to see that board? Because I'm not sure he can. Can you see that board?
I can see it.
Oh, never mind.
A little
You can
bit.
see it.
A little bit.
And 37 likes, right?
Yes.
Now, you said you've been watching some of this trial, right?
Yes.
You know that Clint Watts testified here earlier this week, correct?
Yes.
And did you hear his testimony that at a minimum, your lies about Sandy Hook reached 550 million just on social media alone? Did you recall that testimony? That's a yes or no.
Yes, I recall it.
You recall it.
Preposterous.
Move to strike, Your Honor.
And so, sir, just remember, no comments, just the
Oh,
answer
yes,
to the
thank you.
question. Thank you.
I'm done with this. Huh? I got it, thank you. Now, Mr. Jones, the lie you spread for years and years was that the families behind me were actors, correct?
I can't
That's
answer.
a yes or no.
No, objection.
It's too complex. Sorry.
Motion to eliminate.
Can I have a sidebar on that? The lies that you spread were the board trial.
He doesn't think they were lies. I mean, the court has made that finding. And so this is the heart of that Fifth Amendment issue I alerted the court to. If he agrees with the characterization that it's a lie, he's testifying falsely. If he testifies truthfully, he's in contempt of a prior ruling of the court.
So I'll do something a little different.
Okay, that's a good point, though.
I mean, look, he could take the fifth. So
If we're going to get to that, I'd rather do it outside the jury's presence because my claim.
I'll try something.
Okay.
Chris.
So just wait for the next question, Mr. Jones. Okay?
Man, I'm sorry.
Yes. We'll let
Mr.
them-
Jones, for years and years and years, you called these families actors, correct?
No.
That's not correct.
No.
Do you remember in your deposition, sir? I asked you about Robbie Parker, right?
Yes.
And you always called Robbie Parker an actor many times, didn't you?
No, I said it looked like he was acting.
You said it looked like he was acting?
The internet is a huge thing.
Mr. Jones, is your
Objection, my
testimony...
client wasn't permitted to finish his answer.
These are not yes or-
No, Mr. Jones, I'm sorry, because now I've lost the question. So can you ask the question?
You know what?
again?
Let's do it this way. Mr. Jones, would you agree with me that if somebody were to lie about a group of people and call them actors and having faked their children's death, that would be a horrible thing to say about something?
I did not call
Is it
them
yes or no?
liars.
As to the vouching in proper form, it's a contrary voucher. Nobody cares whether he agrees with Mr. Manager.
All right, sustained.
Mr. Jones, if someone were to falsely claim that a group of families who had lost loved ones were actors and had faked the deaths of their loved ones, that would be a horrible thing to say, correct?
In the context, it could be, yes.
Could be. And if somebody were to spread that claim to millions and millions and millions of people, one would expect those families who have been falsely accused to be damaged, correct?
Objection, speculation, Judge.
Yes or no, sir?
I cannot answer this question truthfully without violating the court's order.
Well, why don't we have an invocation then?
What's an invocation?
Oh, no, wait, Judge. We need,
All
this is
right.
improper. I'm going to object.
So, why don't I excuse the jury for a minute? This shouldn't be too long. Okay, so the question again?
Well, Judge, before we go on, we had an agreement that if there was going to be any Fifth Amendment claims here, it would be done outside the presence of the jury, and then we're asking for an invocation.
When you say we had an agreement, you and the attorney?
Well, no, Attorney Pattis requested that. I wasn't prepared for him to invoke on that question.
Well, I don't know, I wasn't part of that agreement, but
I'd
let's,
ask for an order that if there's going to be any further effort to evoke the Fifth Amendment or to elicit a Fifth Amendment response, to be done outside the presence of the jury.
That's fine, but that's not what I was doing. I think the question will show that there's no valid assertion there.
all right, well, why don't, can you give me the question again? Or do you want me to play it back?
Yes.
Why don't we play it back?
Okay, take your time, Madam Monitor.
Were actors. They faked the deaths of their loved ones. That would be a horrible thing to say, correct?
In the context, it could be, yes.
Good. And if somebody were to spread that claim to millions and millions and millions of people, one would expect those families who have been falsely accused to be damaged, correct? Objection, speculation. Yes or no, sir?
I cannot answer this question truthfully without violating the court's order.
Well, why don't we have an invocation then?
What's an invocation?
Oh, no, wait, we need
All right, you can go back, just for anybody else. Okay,
So we alerted the court earlier on that there may be an unusual Fifth Amendment issue in this case arising from the law of the case. Mr. Jones has suffered a disciplinary default in this case, resulting in his inability to contest liability. The court has established during the law of the case that
can we just back up for a second? So the question wasn't about Mr. Jones specifically, although maybe it was getting there. The question was, if someone spread that claim to millions and millions of people, one would expect people to be damaged. There's no...
No, there was you're missing a predicate in there, falsely. If they falsely spread this information.
Right, but this is not talking about Mr. Jones or free speech systems. This was a hypothetical.
He's not an expert, and he can't be questioned as an expert. He's here as a fact witness. And the fact that this is an attempt to sidestep the ruling and once again have the motion in limine be used as a sword rather than a shield. We didn't make motions in limine to limit this material. The plaintiffs did. The contention here is that Mr. Jones, the law of the case is that the court has concluded these statements were false, not because they were litigated, but because of failure to comply with discovery. We can't talk about that. The plaintiffs have earned the right to call him a liar in open court. Whether we agree or not, that's the law of the case. What they've not done is earn the right to put him in a position where he either disagrees with their characterization of him, thus running afoul of a prior ruling of the court, or agrees with them, thus committing perjury. We would go further and say that if we get to a point where an invocation is necessary, they're not entitled to an adverse inference because that is giving undue weight to
So,
a
Attorney
disciplinary
Pattis,
default.
what would be wrong if his answer, his true answer, how would it violate the order, is if he says he denies the extent of the damage?
I don't know that that's responsive to the question, candidly.
Yeah, so, Your Honor, I think what's happening here is we had a sidebar to avoid a proper assertion. I said I'll do it a different way. And so I came back here, and instead of telling Mr. Jones that he had lied, I said if one did, that would cause damage.
Well, who cares?
Well, I think,
Yeah.
it's got to be asked in a way that, and I don't want to tell you how to ask it, but
You know, this is,
no, let me just
I'm sorry.
get it out. Where we're not putting Mr. Jones in a pickle, but where the jury understands that the issue has been decided, which they've been told many, many times now. So can you think of a way to do it along those lines? So here, the court has already determined that liability is not an issue. The jury is just determining damages. And so what's the question for Mr. Jones?
No, there is no, first of all, he's a defendant. This isn't
I'm
impeachment
just
on
asking
credibility
what
grounds.
the question is, though.
The question is, rather than ask him directly, where he now thinks, you know, a truthful answer would somehow incriminate himself, I've asked him whether or not one would expect that if one were to do these things, it would cause harm. Now, Attorney Pattis is still free to argue at any point that the harm caused here wasn't what the plaintiff's alleged. That's what he's apparently claiming. But Mr. Jones's response to that question, if the answer is yes, one would expect that type of harm. That doesn't violate the court's orders, and it's not false. If the answer is no, one wouldn't expect that. That doesn't violate the court's orders, and it's not false, right? So either one, he can testify truthfully without violating the court's order and putting himself in contempt.
Or I don't know.
Or I don't know.
All right, so
The
how
problem
does...
with that, Judge, is it's argumentative in tone. He's not an expert, and so what one does isn't what we're
But
here to
that's-
show.
but-
We're here to show what he did.
Right, but
And the
that's a
purpose is
different,
being
no,
offered to
Attorney
get into the
Pattis,
state of
Attorney
mind.
Pattis, Attorney Pattis, how many times do I have to say when I'm speaking, you stop? You have been a member of the bar for a long, long time, and you know the rules in all the courts. So, your objection was that it was a motion in limine issue, I thought, that it would require him to lie. I now hear that it's a different objection, that it's speculative, he's not an expert.
I'm waiting to finish, so I don't want to follow your order. I have been in offshore court for a long time. As you know, I insist on making my record, so thank you. And I'm sorry that I stepped on your question. I thought I wasn't done. What I was trying to say was the following. I objected because he's trying to get an evocation in the jury's presence, which is entirely a problem, without permission of the court. I objected further because he was asking Mr. Jones a question that places him on the horns of the dilemma. In the course of his proffer outside the jury's presence, he's now switched it to one would expect. That is simply not relevant. That's argumentative. He's a fact witness. His state of mind about his conduct is...
I can't disagree with that, so I will sustain the objection. And where does that leave us with respect to possible future invocation?
If there's going to be an invocation, I've requested it be prelude to it be outside the jury's presence so that I can argue about whether the plaintiffs are entitled.
All right, so how does that work procedurally? So
Motion.
there's a question. You're going to invoke on his behalf?
I can't do that, I don't think. I'm
think-
asserting the jury's presence. I'll argue, I'll simply say
think in a
motion
civil
about
case.
evocation.
I think
Motion
in a-
about evocation.
Okay. Does that work, Attorney Matty?
Sure, that's fine.
Okay, so if that happens, Mr. Jones, if that happens, just put the brakes on, okay? So that we can do it. So, okay, let's bring the jury out. So, can I just see counsel in the meantime? So I can count on one hand how many times I've argued. 1 hand,
You're right.
That's in there. That's a positive
no,
note.
Look, Judge, here's the deal. I'm an advocate. I get lost in the moment. You've admonished me, and I'm working on it.
You're standing up for your objections, right?
I'm a member of Advocates Anonymous, Judge. If I warm too much to my client's cause, that's why courts are here to ensure fair trials.
We're good.
Okay, welcome back. As promised, we were pretty quick, so thank you for your patience. Please be seated. The record will reflect that our entire panel has returned. Let's give them a minute to settle in. And whenever you're ready, Attorney Madden, please.
Thank you, Your Honor. You remember in your deposition, sir, you referred to, I asked you some questions about Robbie Parker, correct?
I'm sorry, say that again?
I asked you some questions about Robbie Parker.
Yes,
I showed you some videos, right?
yes.
And I showed you a video where you were describing not just one parent, but a bunch of parents coming up and doing the fake crying and the laugh. Do you remember that video?
No, I don't.
Why don't we show 19...
Which exhibit is this? I'm sorry. 19?
19I.
A as in
19I.
I.
It is a full exhibit.
Thank you.
CNN admits they did fake scud attacks on themselves back in 1991, 1990. Would they stage this? I don't know. Do penguins live in Antarctica? Wolfgang W. Halbig's our guest, former state police officer, then worked for the Customs Department, and then over the last decades created one of the biggest, most successful school safety training groups, and he just has gone and investigated, and it's as phony as a $3 bill, and they've been, but man, Wolfgang, you dropped a bombshell of your scores of points, your 16 questions. If you've got a school of 100 kids, and then nobody can find them, and then you've got parents laughing on, and then they walk over to the camera and go, and, I mean, not just one, but a bunch of parents doing this, and then photos of kids that are still alive, they said died. I mean, they think we're so dumb that it's really hidden in plain view.
So, Mr. Jones, does that refresh your recollection about referring to not just one parent, but a bunch of parents doing the fake crying and the laughing?
Yes, it does.
Okay. And when you were deposed, you acknowledged, did you not, that you had referred to the parents who had brought this case as actors. Didn't you acknowledge that then?
I mean, the only person's name I ever said was Robbie Parker, but I guess that clip's from like 7 years ago or wherever it is. All long time ago.
So, Mr. Jones, just let's get back to it. Make sure
Oh, sorry. Sorry.
So the question was, do you remember in your deposition where you acknowledged that the families who had brought this case you had called actors? Do you remember that testimony, sir?
I think we've had like 4 depositions. Which one was it?
You remember you were in my office?
Yes.
We were in a conference room?
Yes.
Okay, I was sitting just about as far as any from the court reporter from you.
I'm trying to remember that we've had quite a few.
You and I have only had 2 in person, correct?
Yes. I mean,
Okay.
and several over the.
We had 1 by Zoom, correct?
No, we had 2.
All right, well, Mr. Jones, I'm talking about the ones when you were in person sitting right next to me.
Okay, that's why I'm trying to even refresh my memory.
So, am I correct that during that deposition, you acknowledged under oath that you had referred to these families as actors?
I don't remember the testimony, but I've never even seen their faces most of them until they sued me. I don't know, so I can't answer your question. I don't have the answer to that.
You just don't remember that testimony is your answer, right?
I believe it's the same testimony I gave her today.
Okay. Okay, well, why don't we, may I approach her?
You might.
Jones, I'm going to ask you, look at page 252. You see this question where I say, I'm asking.
Which exhibit, sir?
This is Mr. Jones's
Oh, there
deposition.
are four of them. Which one is that?
April 5th, 2022.
Page 252.
Thank you.
I'm asking if you'd agree with that. You've given me two options here. One option is it is just an actor playing a character. The other option is it is somebody who is really who they say they are, but they're going along with the official script. Those are the options you gave me. Answer, yes, that's what you said, right?
Yes.
The first option, Robbie Parker is an actor creating a role. In that circumstance, Robbie Parker is just a fictitious character, correct? What'd you say?
Yes. That's role playing, yes.
You said yes, right?
Yeah.
In that context, the actor playing Robbie Parker would be going out in front of the whole world to give a statement, knowing that he's just playing a fictitious part, correct? What'd you say?
Yes.
You remember in your deposition you acknowledged that for this hoax to work, it couldn't just be Robbie Parker who was an actor. They all had to be in on it, correct?
You've refreshed my memory. I believe I was answering your hypothetical questions.
Okay. Listen to the question I just asked
All right.
you. You acknowledged in your deposition that when you were calling this a hoax, that in order for this hoax to be pulled off, it wouldn't just be Robbie Parker, it would have to be all the families who were actors, correct?
Objection to the
We're
form.
recovering the controversy of was it staged or not.
Move to strike, Your Honor.
Sustained.
Can you answer that question, sir?
Can you refresh me with the transcript?
Sure.
The last one was
do that
very
again.
helpful.
In fact, you know what, let's just pull it up for everybody.
So this is exhibit.
One moment, Your Honor. We have this clip, right? Now, we're going to play a portion of Mr. Jones's deposition. It's an admission.
What was the exhibit number on this, Judge?
It's not an exhibit, it's an admission. But
What-
we'll get to the number for the deposition. Thank you for your patience, Your Honor.
No problem.
While we're doing that, Mr. Jones, what's a Potemkin village?
A Potemkin village, I believe, goes back to examples like before the Russian Revolution, czars would build fake villages for PR stunts. Then I think there was some, I read the exact historic nature of it. I may be wrong about that. It's something to do with Russian history and government staging events.
Right. And this Potemkin village would be filled with people to play
parts as if they were villagers, correct?
Yes.
Actors in a hoax that the government was staging.
It's like the Truman Show.
And the Truman Show, that's a movie, yes?
Yes.
Where this fake village is plopped down and everybody who populates it is in on the hoax, yes?
I think that's what the movie's about.
And that's what Potemkin Village is, to your understanding.
It's got a lot of definitions, but I think that's a fair one.
Is that about right? Is that how you were using it when you were deposed?
You have to refresh my memory.
That's what we're trying to do here. All right, we'll play that.
Sorry, Council, what exhibit number is this?
Your claim, in response to my question, that there's a fictitious person named Robbie Parker with an actor playing, you'd agree with me that by going in front of the camera to millions and millions of people, there would be somebody who would know, hey, I know that guy. That's not Robbie Parker, right?
Objection.
Objection. Just answered that question. Do you think that, is that a reasonable expectation?
No.
Okay.
Objection.
And if somebody were to recognize,
It's a Potemkin village.
if somebody were to recognize the person playing Robbie Parker isn't in fact Robbie Parker, that would blow the whole hoax, right?
Objection.
Objection. You know what a Potemkin village is?
Answer my question.
None of us a Potemkin village.
Okay. By Potemkin Village, you mean everybody who was in the immediate community would have been in on it.
Well, they set that up
Right.
during World War II.
That's
didn't
what, no. That's what you mean, that everybody in the community is
they?
in.
Not everybody, but in a close-knit area.
Okay. Which would mean it's certainly all the parents of children who were killed would have to be part of that conspiracy, right?
Objection. Or maybe it didn't even happen.
That'd be a good time for lunch break, Your Honor.
I think so.
Your Honor, I just need to know what exhibit that was.
Can we get that too?
Yes, this I think is 372.
372?
Yes, Your Honor.
Okay, so we will take our lunch break. We'll be back right for 2 p.m. It is as imperative as always that you continue to obey the rules of juror conduct. Ron will take your notepads. If you go out, I'm not sure what the weather's like, it's hard to tell, but if you do venture out, just make sure that as you come back in, you avoid any of the witnesses or parties or lawyers associated with the case and any media that you might see. So I hope everyone has a nice lunch. We'll take a recess.